These are people who supposedly want their job back. But here's the thing. Federal district trial courts do not have infinite jurisdiction to cover any subject matter they want. They only have the jurisdiction Congress allows them. And Congress took away from the federal district trial courts jurisdiction over employment disputes. They created the Civil Service Reform Act. They created the Merit Service Protection Board. There are administrative avenues that people are obliged to pursue over employment disputes, not federal district court. So this court doesn't have jurisdiction over these cases either, as well as there being no standing. Respondents collaterally challenged the legal basis for terminating these employees. They're not the ones getting fired, these plaintiffs. They're complaining that the fired people, because they were fired, will lose them opportunities like access to the swimming pool, in my analogy. But Congress requires employees themselves, not nonprofits who are strangers to the employment relationship, to challenge individual determinations through the prescribed process under the Civil Service Reform Act of 1978, the Merit Service Protection Board. If you're ever compelled to use force in defense of yourself or your family, the good news is that if you defended lawfully, you can be very hard to convict. But did you defend lawfully? Because if you don't know where the actual legal boundaries for self-defense are, it's the easiest thing in the world to innocently step over them, and now you're extremely easy to convict. Good news. In just a single day, you can become an expert on the law of self-defense and make yourself extremely hard to convict. On Saturday, April 26th, I'm holding one of my only twice-a-year full-day Law of Self-Defense advanced classes. This class is taught live by me and live streamed to you. It teaches you everything you need to know in one day, and there's plenty of opportunity for personal Q&A with me as well. Even more good news, when you register today, you save yourself 50% off the standard registration, but that discount ends soon. Your 50% discount and many more details on this advanced class are available just by pointing your browser to lawofselfdefense.com/advanced today. And I'll also drop that link in the description. I look forward to seeing all of you there. Welcome to another episode of the Law of Self-Defense, where we get to celebrate Trump's unbelievable winning streak in the last week. At least a 4-0 winning streak with the Supreme Court. I would argue, because we got an ancillary knockout on another federal court, it's really a 5-0 winning streak for Trump with the Supreme Court in just the last few days. I think it's really important to put all this into perspective. So those of us who support President Trump and his efforts to save our nation from demographic, political, and economic implosion can really luxuriate in the full warmth of the victories that are happening. So let's get into it. Let us get into it. Today, Tuesday, April 8th, President Trump scored yet another huge win with the Supreme Court, with Chief Justice John Roberts announcing that SCOTUS was acting to stay or freeze the order of leftist, unelected, tyrannical, black-robed, inferior, way left progressive woke DEI federal judge William Alsup in San Francisco, who'd ordered that President Trump was compelled by the will of Judge Alsup to rehire 16,000 executive branch employees who Trump had fired. This ruling by SCOTUS follows on two Supreme Court wins just yesterday, one affirming Trump's authority to deport Tren de Aragua invaders under the Alien Enemies Act of 1798, and another affirming Trump's authority to deport MS-13 members as terrorists, all of them to the lovely Seacot Resort in El Salvador. And that follows on the Supreme Court win last Friday, affirming Trump's authority to cut off $600 million in DEI funding from the money laundering swamp NGOs. And if $600 million doesn't sound like a lot of money, given the figures we've been throwing around here lately, That ruling led to yet another judge reversing his own order that Trump had to pay out trillions of dollars in DEI, anti-white, racist anti-white male funding. If America's greatest enemies could only have imagined that they could make us do this to ourselves, America gut itself. So today we're mostly going to take a look at the argument that won today's victory in the Supreme Court, the argument by Trump's Solicitor General, the lawyer for the White House, for the administration, the argument he made to the Supreme Court why they should stay crazy Judge Alsup's order to President Trump to compel Trump to hire back 16,000 fired federal employees that Trump did not want. In other words, compelling our Article 2 executive branch president, elected by the whole of the American people, to carry out our political will, in whom the U.S. Constitution bestows 100% of the executive authority of our federal government. This little pipsqueak, black-robed, unelected, tyrannical, inferior district trial court judge believed he had the authority to order around an entire branch of government as if that president was his court clerk. That's where we're going to focus our efforts on that winning argument. But I did want to spend a little more time luxuriating in some of this other stuff. So let's take a look at some of this lovely, lovely stuff. One of the recent wins, Department of Education versus California. This is where the Department of Education had decided to stop paying out $600 million in, this is what I was looking for, the complaint. A bunch of states said, no, President Trump, you can't cut off our racist anti-white male DEI funding. We want that money. And they sued him in federal court. And they got a TRO just a couple of days after that lawsuit. Well, here's the lawsuit. This was on, March 6th. Within 4 days, they had a temporary restraining order issued by the judge ordering Trump to immediately pay out $600 million in racist anti-white male DEI funding. And at that end, the Supreme Court said, nope, President Trump doesn't have to spend that money. And if you think $600 million isn't that much, and I guess in the scheme of how much money, billions and trillions, our U.S. government is wasting, maybe it's not that much. That decision led directly to another decision in another case. This one out of Rhode Island, where a bunch of states had sued for trillions of dollars in racist anti-white male DEI funding that Trump had cut off. Trillions of it. They sued on January 28th, within a week of Trump being sworn in. And within 3 days of filing their complaint, they got a temporary restraining order ordering the Article 2 executive branch president to pay out trillions of dollars in federal spending. Well, guess what happened? After the Supreme Court's decision with the $600 million case, California versus Department of Education, this judge in Rhode Island, who'd ordered trillions of racist anti-white male DEI money spent by Trump against his will, against the will of the Article 2 executive branch president, this judge suspended his own order. Judge John McConnell, in light of the recent Supreme Court order, Department of Education versus California, the court temporarily stays its own TRO, commanding President Trump to spend trillions in racist anti-white male DEI funding. So the first case may not have sounded like a lot, but it had the ancillary effect of also taking out State of New York v. Trump. Trump doesn't have to pay that money. Then, of course, we have the Tren de Aragua. How would Trump say it? Tren de Aragua. He would make the accordion hands, of course. We got the complaint on this one on March 15th. This is the one where 5 Tren de Aragua guys were complaining that they were being summarily deported under the Alien Enemies Act due to Trump's proclamation invoking the Alien Enemies Act on March 15th. Somehow these guys had a law firm ready to file a 24 page motion for them that same day got themselves pulled off a plane about to leave for El Salvador. This is Judge James Boasberg's court. And these guys sued. Although they were being detained in Texas, they sued in the District of Columbia for some bizarre reason. I covered much of this in this morning's show. They sued on March 15th. And how many days do you think it took for them to get a temporary restraining order against Trump? Not only to keep them from being deported under the Alien Enemies Act, but the judge ordered that every plane currently in international airspace carrying some 300 TDA invaders of America to the lovely Seacot Resort in El Salvador. The judge ordered those planes turned around. Did they have enough fuel? Who cares? The judge controls all. He has infinite authority, infinite jurisdiction. It extends even into international airspace. You know how many days it took for these 5 guys? And by extension, because the judge decided on his own initiative to create a protected class of everybody in America who might fall under the Alien Enemies Act proclamation, meaning every violent invader in America got this judge's protection. You know how many days it took? 0 days. That day, the judge issued a TRO to protect these TRO members. How'd that work out? Not as great as it might have, because the Supreme Court yesterday issued its order saying, nope, the president has the authority to exercise the Alien Enemies Act. Judge Boasberg, you are done here. Another win for Trump at SCOTUS. And we're not done yet, because another one of these immigration cases we have, and remember, there's really 3 buckets of these cases. There's the spending cases, like the California versus Department of Education and the New York State versus FEMA cases I mentioned at the beginning, saving trillions of dollars in racist anti-white male spending. Then there are the immigration national security cases. Tren de Aragua and Alien Enemies Act was one of those. A second one of those is this one, the Abrego Garcia case. This is the MS-13 member who's getting deported because MS-13's been designated a terrorist organization. This guy's had a final deportation order for 6 years and just decided to ignore it. But after MS-13 was designated a terrorist organization in March by Secretary of State Marco Rubio, they grabbed him and they summarily deported him also to the lovely Seacot Resort in El Salvador. And his family complained, and on March 24th, they filed a complaint in federal court, and within a week, they had a temporary restraining order in which President Trump was being ordered by an unelected, black-robed, tyrannical, inferior federal trial court judge to return an identified terrorist back into the United States by midnight. The arrogance of these judges. How'd that work out? Pretty well for Trump. Pretty well for Trump. Yesterday, Trump got an order from the Supreme Court saying, nope, we're vacating that order. This guy, Abrego Garcia, does not have to be returned to the U.S. None of these MS-13 people are going to be returned to the U.S. President Trump has the authority to deport identified terrorists from the United States of America. Another win for President Trump. And we're still not done, because we have today's win. Today's fantastic, beautiful win. This is the case in which crazed leftist, unelected, black-robed, tyrannical, inferior district trial court judge William Alsup in San Francisco decided he had the authority to order the Article 2 executive branch president to rehire 16,000 federal employees that Trump had fired, because the judge would know whether these people were needed in the executive branch of government. These people filed a complaint on February 20th, 19th, that they'd been fired. Within a week, Judge Alsup had issued an order, temporary order, that every one of these 16,000 people be rehired by President Trump. That apparently the judge believes he has greater executive authority than the Article 2 executive branch president, to whom the Constitution bestows 100% of executive authority. of the federal government, elected by the American people to exercise our political will. But no, Judge Alsup has greater executive branch authority than that. He issued that order. Trump fought against it in court. And one of the ways he fought against it in court was he had his Solicitor General, the lawyer for the executive branch of government, argued to the White House why Alsup's order should be stayed or vacated. Stayed, I guess, frozen. And guess what happened today? This, by the way, is the document we're going to spend most of the show on. Today, the U.S. Supreme Court, in fact, stayed that order of Judge Alsup. These 16,000 people do not have to be rehired. This just went out as a text message this morning when I saw it, so I'll just read it from here. The application for stay in the Alsup case was presented to Justice Kagan. She's just the person to whom applications from the Ninth Circuit are sent. The March 13th, 2025 preliminary injunction entered by the United States District Court, the unelected black-robed tyrannical inferior trial court judge, William Alsup, his preliminary injunction ordering Trump to rehire 16,000 people is stayed pending the disposition of the appeal in the U.S. Courts of Appeal in the Ninth Circuit and presumably a writ of certiorari to the Supreme Court if one is sought. The district court's injunction was based solely on the allegations of the 9 nonprofits who managed to spend billions of dollars of our tax money, was based solely on the allegations of the 9 nonprofit organization plaintiffs in this case, but under established law, those allegations are insufficient to support the organization's standing. What does standing means? Standing means that you have some kind of legal right that you're defending in court, a material legal right, not just that you might lose something of value, but something you have a right to. Now, imagine, for example, you have a wealthy neighbor. He's got a very high-paying job. He's got a beautiful swimming pool, and he lets you just use that swimming pool whenever you want. And then he gets fired from his job, arguably unlawfully, wrongful termination. He can sue them for wrongful termination. He has standing. He has a material right at stake. Would you be able to sue because now that he's lost his job, he had to sell that house and you don't have access to his pool anymore? So you've lost something. You've lost access to the pool. Can you sue his employer for their wrongful firing of him because of your loss of access to that very nice pool? The answer is no, because although you have lost access to the pool, you did not have a legal right to that access. You do not have standing to sue over his wrongful termination, even if it has negative consequences for you. Now, this appears to have been a 7-2 Supreme Court decision, a refreshing change from all the 5-4 decisions we've been seeing. The 2 holdouts here were Sotomayor, Justice Sonia Wise Latina Sotomayor, whose reading of her dissents literally obliterates IQ out of your brain, and Justice Ketanji, I'm not a biologist, how would I know what a woman is? Jackson. They were the dissenters here. And their argument, I'm not going to read their argument, but their argument is, well, the government can't show irreparable harm. Hiring these 16,000 people back, how would that harm the government? As if the government expending the vast sums of money required to hire these people back and pay them when the government believes they're not needed. It's not like that money can be recovered. That is irreparable harm. All right, so this is the document I want to share with all of you because this was the winning argument. This was the argument by the Solicitor General of the U.S. for why the Supreme Court should stay this ridiculous, crazed order that a trial court judge can order the President of the United States to rehire 16,000 people against that president's will, the Article 2 Executive Branch President of the United States. Now, this was, of course, filed before we got the favorable Supreme Court decision today saying that Judge Alsup cannot order President Trump to rehire 16,000 people. It was prepared by John Sauer, the, I believe, very recently appointed Solicitor General, very good reputation as a lawyer. And he's arguing for why Judge Alsup's order to President Trump should be stayed. Office of Personnel Management, that's the executive branch agency that fired these people, and a whole bunch of the people who were fired, mostly unions, by the way. This is key here. So this is not the fired employees suing in their own name to get their jobs back. This is their unions suing. And the unions are claiming their damages are the loss of the union dues that these people would be paying if they were still employed. Does this sound like the swimming pool analogy I just shared with you earlier? I think it does. And I think that makes a standing issue here, which is what John Sauer's going to be arguing. So I'm going to start diving into the meat of this, and it's relatively short for one of these documents, but this was the argument that the Supreme Court found most compelling. The district court, this would be the court of unelected, black-robed, tyrannical, inferior trial court judge William Alsop, granted a preliminary injunction forcing the government to reinstate 16,000 probationary employees because some members of respondents' nonprofit organizations might benefit in some unspecified fraction of those employees conducting tasks like processing disaster relief, performing natural resource monitoring, protecting recreational fishing activities. The federal government must immediately reemploy all those workers, according to the judge, despite the agency's judgment about what best serves their mission. Moreover, agencies would apparently subvert the court's reinstatement order if they decide to assign probationary employees to entirely different tasks. So not only is this judge ordering Trump, he's got to rehire these people, but he's telling the executive branch, you can't even direct or manage these people. Courts do not have license to block federal workplace reforms at the behest of anyone who wishes to retain particular levels of general government services. The injunction in this case plainly exceeded the district court's authority. The court should have dismissed the suit on standing grounds. Respondents' asserted harms, they're going to lose out on that swimming pool access, involve speculative, far downstream consequences of terminating federal employees. But Article 3 requires plaintiffs to identify, Article 3, judicial branch of the Constitution, requires plaintiffs to identify concrete injuries traceable to specific wrongful acts. The court should also have dismissed the suit for circumventing the exclusive power Congress prescribed for challenging specific federal personnel actions. So these are firing cases. Remember, I talked earlier about the 3 buckets of cases, spending cases. Those were the first 2 wins for Trump we covered. Immigration and national security cases. Those were Abrego Garcia and the TDA folks under the Alien Enemies Act. And firing cases. This is one of the firing cases. These are people who supposedly want their job back. But here's the thing. Federal district trial courts do not have infinite jurisdiction to cover any subject matter they want. They only have the jurisdiction Congress allows them. And Congress took away from the federal district trial courts jurisdiction over employment disputes. They created the Civil Service Reform Act. They created the Merit Service Protection Board. There are administrative avenues that people are obliged to pursue over employment disputes, not federal district court. So this court doesn't have jurisdiction over these cases either, as well as there being no standing. Respondents collaterally challenged the legal basis for terminating these employees. They're not the ones getting fired, these plaintiffs. They're complaining that the fired people, because they were fired, will lose them opportunities like access to the swimming pool, in my analogy. But Congress requires employees themselves, not nonprofits who are strangers to the employment relationship, to challenge individual determinations through the prescribed process under the Civil Service Reform Act of 1978, the Merit Service Protection Board. In addition, the district court vastly exceeded the permissible scope of relief. Traditional equitable authority would not allow such reinstatements, much less 16,000 employees, and the APA does not support preliminary injunctive relief here. The APA is an act that's supposed to prevent arbitrary administrative policies by the government. It does not apply if there's some specific process for addressing the pursuit, and there is here. Concerns about how federal workforce reductions might affect services provided to the public and fragile ecosystems, in other public lands cannot support forcing the executive branch to rehire all 16,000 employees, no matter what their jobs involve. If this suit could proceed, the process that Congress actually prescribed for challenging terminations, suits under the Civil Service Protection Act, would be largely superfluous. Employees would have little reason to bring their own suits via individual adjudications that culminate in federal circuit review. Nonprofits could always leapfrog that process, sue anywhere their members use any federal services, and demand reinstatement for everyone based on isolated downstream harms. This Supreme Court should not invite a new wave of litigation to micromanage federal employment, where the executive branch would cede its prerogatives to district courts, unelected, black-robed, tyrannical, inferior district trial courts that second-guess which personnel and job functions are essential. One way you get a stay of an injunction is to show that you're likely to win on the merits, not the other side. And here he argues, John Sauer, Solicitor General of the U.S., that the government is likely to win on the merits. Multiple threshold barriers, in other words, things that make a suit illegitimate from the start, standing, jurisdiction, and limits on equitable relief should have precluded anything remotely resembling the district trial court's Judge William Alsup's extraordinary injunction. Respondents, the people who want the 16,000 hired back, pivot to the merits of the case, but nonprofits cannot wield longer bathroom wait times at national parks, which is what they're complaining about, to obtain review of thousands of employment terminations outside of the designated process for doing that. Nonprofit organizations don't have standing. They cannot establish Article 3 standing to litigate whether 16,000 employees were properly terminated, with scattershot speculation about how losing some of those employees might impair some of the agencies, a small subset of services. As to claims involving the VA and the Department of Defense, the district court relied solely on the theory that the organizations themselves suffer injury by having to divert organizational resources to counteract the effects of the agency's actions. But this Supreme Court rejected that theory in FDA versus Alliance for Hippocratic Medicine, explaining it has been careful to not extend other decisions holding beyond its context, and that an organization cannot spend its way into standing by expending money to gather information and advocate against the other side's actions. Respondents, the people who want these people hired back, maintain they will divert so many resources as to impede their ability to perform core business activities. But whether they spend a lot or a little, they cannot spend their way into standing. It's as if you were spending money to improve your neighbor's pool. You still don't have a right to the pool. As to the other agencies' respondents' other theory of standing, that their members want to use federal services that would likely be disrupted by probationary employees' terminations, does not satisfy Article 3 standing either. Respondents complain that terminating thousands of probationary employees will translate into service disruptions and describe their anecdotal evidence as voluminous. Missing, however, is any specific injury that members will face because of particular terminations at particular agency. Respondents forecast injuries from likely impairment of disaster relief, likely failure to obtain timely loan guarantees, and likely damage to sensitive ecological areas within national parks. But allegations of possible future injury do not suffice for standing, let alone allegations that do not specify how many affected employees perform the relevant functions and how many are left. Respondents provide declarations opining that a lack of U.S. Forest Service oversight of cattle grazing could have adverse environmental effects, and assert the Department of Agriculture grant programs for small businesses may be less efficient. These are not concrete injuries. Respondents also sidestep significant causation and redressability problems. Each of the respondents' supposed injuries depends on a highly speculative, attenuated chain of causal inferences. They speculate that reinstating probationary employees might result in their resuming the same tasks the same way, and might then improve federal services that some of their members might use. Even if isolated instances of diminished federal service qualified as injuries, they were not caused by the termination of all 16,000 probationary employees. The problems, if any, would be with respect to particular probationary employees involved in particular tasks. That cannot justify reinstating all 16,000 people. Further, respondents, the people who want these 16,000 folks hired back, apparently concede that appropriate relief in this case would not prevent agencies from terminating employees for reasons other than the OPM's instruction, Office of Personnel Management. It's like the executive branch HR department. That further illustrates respondents' failure to prove redressability because the judgment respondents seek would leave the agencies free to terminate the same number of employees, thereby inflicting all the same supposed downstream harms to federal services. Even if the agencies chose to retain the terminated employees, that does not mean they will return to the same positions and assignments, or that the agencies will provide the services that the organizational plaintiffs desire. The various agencies might well reassign those employees to new positions, or assign them different tasks, or prioritize their mission and services in a manner that does not result in increased services to the organizational plaintiffs. Respondents dismiss these outcomes as pure speculation, yet their own theories of standing rely on even greater conjecture about whether the loss of probationary employees would reduce processing of student loans or scientific research. If respondents' allegations can establish standing to challenge thousands of terminations, virtually any nonprofit could show standing to sue virtually any federal employment decision just by pointing to some speculative downstream consequence from some aspect of the termination. Nonprofits supporting the elderly could challenge terminations of administrative law judges on the theory that slower processing time for Social Security claims would reduce standards of living. Nonprofits representing travelers could challenge State Department terminations that might reduce passport and visa processing times and cause canceled trips. This is not how Article 3 works. Respondents cannot paper over those flaws by invoking deference to the district court's findings of harm and causation. Second point about these firings, the Merit Systems Protection Board. This is a separate, independent administrative process for seeking redress for wrongful terminations. That jurisdiction has been stripped from the unelected, black-robed, tyrannical inferior district trial courts of the Article 3 branch, the judiciary. Separately, the government's likely to succeed on the merits because the district court lacked jurisdiction to assess the legality of government personnel actions and to enter an injunction ordering reinstatement. Congress set out a comprehensive system for reviewing personnel action taken against federal employees in the CSRA, and that deprives federal district courts of jurisdiction to repackage challenges to personnel actions as APA claims. Respondents contend that because they are third parties, not federal employees or unions acting in a representative capacity and cannot sue under the CSRA, they must be permitted to go directly to the unelected, black-robed, tyrannical, inferior trial district courts. But it is the comprehensiveness of the statutory scheme involved, not the adequacy of the specific remedies, that precludes jurisdiction by the courts. The CSRA does not perversely prevent actual employees from going to court over employment decisions while allowing nonprofits who are strangers to the employment relationship to press for those same district court lawsuits outside the administrative process. Respondents disregard that their suit seeks to undo specific personnel actions and thus falls into the heartland of challenges that Congress wanted only the Merit Service Protection Board to resolve. Respondents similarly insist that the APA review is available to challenge Office of Personnel Management actions. It must be available to challenge specific personnel actions. This is wrong. The MSPB exclusively handles that kind of personal wrongful termination action. Respondents cannot evade the CSRA administrative process by repackaging their suit as a challenge to government-wide actions. That attempt to challenge thousands of terminations decisions in one swoop only aggravates the problems with circumventing the CSRA's individual process. Let's see. The respondents attempt to seek to enforce an executive order. I'll start at the beginning. Respondents invoke the government's complaint in Department of Defense, First Government Union, which seeks to enforce an executive order relating to collective bargaining agreements with unions. Respondents suggest that if a district court has jurisdiction over that action, a district court must have jurisdiction here. But there, the president, acting pursuant to statutory authority, exempted the relevant agency's relations with the unions from the CSRA entirely. That express exemption takes the validity of those agencies' agreements with unions outside the CSRA comprehensive scheme. Here, nothing exempts the at-issue personnel actions from CSRA coverage. And respondents do not dispute that employees challenging these same terminations must proceed through that administrative scheme. Because the personnel decisions at issue here fall within that administrative scheme, they can be challenged only pursuant to that scheme by actual employees, not bystanders, neighbors like respondents. At bottom, respondents posit an implausible and illogical scheme whereby Congress crafted an exclusive, reticulated framework requiring employees to litigate in the Merit System Protection Board, but left distant actors free to challenge those same employment actions in any regional, unelected, black-robed, tyrannical, inferior district trial court circuit. That scheme would give nonprofits and anyone else indirectly affected by terminations greater rights than were available to employees who enjoyed rights under the statutory scheme, by providing them with remedies that may not be available to the employees themselves and allowing them to proceed directly to unelected, black-robed, tyrannical, inferior trial court federal judges. That scheme would constantly risk conflicting decisions about the same specific personnel actions. District courts in California might agree with an advocacy group that alleged wrongfully terminated a handful of people, whereas the federal circuit might disagree in cases brought by the employees themselves. Worse still, plaintiffs of all stripes could challenge the same specific personnel actions in multiple regional circuits, as is happening with these very personnel actions. There's another suit going on in Maryland about these same terminations. Congress did not enact a circumscribed, integrated scheme of review in the civil service just to let strangers to the employment relationship pick and choose among legal theories, remedies, and forums outside that statutory scheme. Reinstatement as a remedy. Preliminarily ordering reinstatement of 16,000 employees clearly exceeds the district court's remedial authority. Respondents' contrary account of traditional equitable practice lacks merit. For instance, respondents assert that this Supreme Court has rejected reinstatement as an equitable remedy only in cases involving state officials. But this Supreme Court has repeatedly recognized that courts of equity lack the power to reinstate even federal officials. The court has explained that the no reinstatement rule reflects a traditional limit upon equity jurisdiction and not upon federal courts' power to inquire into matters of state governmental organization. I'm going to skip a little of this precedent stuff. Respondents alternatively try to find other sources of reinstatement powers. They invoke the APA, the Administrative Practices Act, that directs courts to set aside unlawful agency action. Whatever set aside means, it does not mean reinstatement. That section comes into play only at the end of a case, once a court definitively determines the agency action is unlawful, not at a preliminary stage, where district court has determined only that the challenged action is likely unlawful. And Section 706 certainly does not authorize the remedy the district court issued, an injunction directing the federal government's conduct. At most, the district court could have set aside the OPM guidance it has deemed unlawful. I'm going to skip some of that traditional equity power stuff. Finally, respondents argue that the underlying firings themselves were unlawful. That would not justify reinstatement as a remedy. Remedies for violations of the law must be created by Congress. Absent statutory authorization, a remedy does not exist, and courts may not create one, no matter how desirable that might seem from a policy matter. Respondents are wrong in contending that there is no real dispute that OPM violated the law. The government vigorously disputed below that the OPM directed the challenge terminations. The OPM is saying we never fired anyone as an organization. The agencies themselves did that. And the agencies have since decided to stand by these terminations after OPM, in compliance with the district court's TRO, clarified that OPM lacks and is not exercising authority to direct personnel actions at other agencies. OPM merely provides HR guidance to what other agencies should do. Respondents asked this court to disregard these events, invoking the voluntary cessation doctrine. But these events illustrate the errors of the district court's ruling, even if the case is not moot. Because OPM never viewed itself as empowered to direct personal actions, the government agreed that the TRO ordering that relief could be converted to a preliminary injunction. In other words, go ahead. Tell OPM they can't fire people. OPM isn't firing people. Instead, the district court summarily entered an entirely different preliminary injunction, ordering reinstatement of thousands of employees to full duty status, sufficient to restore government services for the benefits of respondents' members. That injunction, which was not the subject of briefing in the trial court, requires relief from this court. Other factors support relief. Let's see. Respondents dismissed the government's primary claim of irreparable harm if this TRO is allowed to go through. The preliminary injunction severely encroaches on the executive branch's authority to direct its internal affairs and imposes enormous practical burdens. So here they're arguing a separation of powers doctrine violation. Respondents call those burdens self-inflicted. Wouldn't have happened if you hadn't fired the people in the first place. But an injury is self-inflicted where an enjoined party has a readily available alternative that it declines to pursue. Here, by contrast, the district court's injunction did not give the agencies any alternative to reinstatement of the terminated employees. Respondents fault the government for not even attempting to show irreparable harm before the district court entered a preliminary injunction. But the government had no occasion to build a record about the harm from reinstating thousands of employees because respondents did not ask for a TRO or a preliminary injunction that included mass reinstatement. The judge did that on his own initiative. Further, respondents now contend that returning employees to work cannot cause irreparable harm because the employees had the same workplaces, credentials, benefits, and training a few weeks earlier. But the reinstatement remedy inflicts a burden given the intervening terminations. Full reinstatement carries the attendant tension with superiors that the agency intended to avoid by dismissal. Respondents disregard the events in the weeks before and even after reinstatement, reflecting substantial changes in staffing and policy priorities. Forcing a return to the staffing and work assignments that existed around early February is a massive practical undertaking. And enjoining agencies from assigning probationary employees to entirely different tasks or projects than they had before they were terminated aggravates the invasion of the executive's prerogatives. Respondents alternatively suggest that despite the injunction, agencies can terminate their employees in compliance with applicable law. If by that respondents mean that the agencies may terminate all the affected employees as long as the agencies, not OPM, makes those decisions, then respondents give away their case. That authority is all the government seeks and is what the enjoined agencies did by adhering to the terminations after OPM's March 4th clarification, but before the mass reinstatement injunction at issue. But if respondents mean that agencies can terminate employees only after obtaining the inferior, tyrannical, black-robed, unelected district trial court's approval, that creates an intolerable day-to-day situation. Agencies cannot manage themselves if they must get unelected, black-robed, tyrannical, inferior district trial court approval for each personnel action they take. Respondents deny that reinstating employees to full duty status inflicts harm over and above forced reinstatement to administrative leave. They note that some agencies returned employees to full duty status, even though the district's order in the Maryland litigation allowed reinstatement to administrative leave. But some agencies did so because the injunction in this case required them to do so. Some agencies, subject only to the Maryland injunction, chose to reinstate some employees to full duty status, but others chose to reinstate some or all terminated employees to paid leave, administrative leave status, illustrating the substantial additional harm inflicted by the injunction here, which denies agencies flexibility to choose among options. Besides, in order to reinstate terminated employees to paid administrative leave status, itself inflicts irreparable harm on the government. And the government has appealed also that Maryland injunction, another firing case. Meanwhile, respondents identify no real irreparable harm of their own. They never explain why their attenuated speculative injuries, like slower review of Freedom of Information Act requests, reduced processing of grant applications, or reduced efforts in combating environmental harm, are irreparable. Respondents only barely address the elevated showing of irreparable injury required for reinstatement, arguing that the injunction here should be free from those requirements because it sought to restore injured parties to the status quo. That could be said in any case seeking reinstatement. Respondent cannot make the showing of irreparable harm of the kind and degree as Sampson requires before a court allows reinstatement of even a single government employee. That failure illustrates the need for relief from the thousands of reinstatement orders encompassed by the district court's injunction in this case. For the foregoing reasons and those stated in the government application, this court should stay the district court's preliminary injunction and issue an immediate administrative stay of the unelected black robe tyrannical inferior district trial court Judge William Alsup's insane, absolutely insane order. Wrong button. And that is exactly what the Supreme Court did today. All those 16,000 people still fired, still fired.